Yo, yo, yo. Thank you for joining us on this special episode, special edition, actually, of the Logistics Lounge. We have some amazing stuff coming up for y'all today. We have Mr. Matt Leffler, the Armchair Attorney. Y'all all know him, y'all love him. Just like you all know and love Mr. Charles Gracey over here with Cents Per Mile. We're going to chop it up about these non-competes, also touch on some non-solicits, that FTC ruling that came down about these last week, and we're just going to have a good time. So sit back, relax, pop a top, and enjoy the lounge. What's crack-a-lackin', everybody? Mr. Hound, what's up, bro? I feel like it's been forever since I've seen you, man.
I know it's been a whole 4 days, 3 days.
Yeah,
however many. It's too long. It's too long. That's why I like these Tuesday shows, man. You know, just gets us on the right track. And today, especially, I have been so excited for this. Just like I can't wait to see what ensues. So appreciate both y'all down here being here. It's gonna be a fun time.
It is going to be a hell of a time, man. A hell of a time. Mr. Gracey, since you were the last to join backstage, how's your day been, brother?
Oh, you know, it's a Tuesday. It's like a Monday, but kind of a continuation of.
Tuesday is the furthest day from next Monday. So this is an important day. We should all be excited for this. I'm excited for every day. Thank you for having me on the show, guys. This is amazing. We're going to talk about post-employment restrictive covenants. Who doesn't get excited about that?
He just named off like a whole audience.
I love Matt's optimism, man. Like everything is like, oh man, it's not just Tuesday. We're this much further away from being Monday again.
I do like that though. I do like that. That's a movement that I can get behind.
That's like me on Friday when someone's like, "It's Friday." I'm like, "It's one day closer to Monday."
Mm-hmm.
Toast everyone's weekend right there.
Right. If you just keep working, you don't have to have that weekend. That's the important part. Right. That's the American dream, is never stopping.
Yes. All right. Well, we're not going to do any news tonight. We are just going to go ahead and get right into it. Guys, just give me a second. I'm pulling up my sticky notes here so we can I can put my tags to make some shorts. Because, man, I'm telling you what, Hunter, I bet you I might have like 3 paragraphs of fucking timestamps from this show, man. Oh my gosh. All right. Well, without further ado, we present Leffler v. Gracey. Boom. Ooh.
Ding ding.
Yeah, that was his whole day. That was his whole Monday's work right there, encapsulated.
No, but you know, that took me like 10 minutes. I swear, dude.
We had to source the wrestlers. We had to set up the whole arena. The trophy's on its way.
I see Gunnar Miller in there, but I didn't see Gunnar, which is.
I'm just glad they didn't ask us to wear leotards.
Man,
an interesting show. That's for the OnlyFans. That's a different show. That's not this show.
I totally was going to go in a different direction with all of this until Charles made that comment yesterday, you know, about just a friendly logistics debate. And then I was like, you know what? No, this is going to be a battle royale. But
it's not.
I'm going to play this up, dude. I was going to be all professional with it, with a little, a judge hitting their little gavel or something. And I was like, no.
I think that's the thing about this whole topic. And I think that's why what Matthew brings to the table on this is the education piece. And we talked about that the last time, is education is lacking in this industry. So I think hearing it from both sides and letting people formulate an opinion based on the facts is important. So I'm excited to hear what you got to say today, Matthew.
Yeah. Me too.
Yeah, and I appreciate that. What I'm hoping to do as we go through this conversation is really to help people understand what is being asked of American workers today. What is being asked by your employer about your future after you leave? And this is a flavor of something called a post-employment restrictive covenant. We'll talk more about these, but I want to be very clear. I have a goal. I have an agenda. I want to persuade you. I want people who are watching across the country, people that are listening to this on repeat, and actually people in this room on this call right now, to understand what is actually being asked of American workers. What is a non-competition agreement? How pervasive are they? And what purpose do they serve? So this conversation is not so much like a debate or an arena, because this story is already written.
Yeah.
We're going to find out what the outcome's going to be, but it happens after this call is done and what work people can do afterwards. I'm very excited to break down what this rule is, what is happening to it, and kind of the history behind non-competition agreements in the United States.
So we're going to go all the way back to government overreach.
Well, let's talk about what this is. So back in 2023, the FTC, the Federal Trade Commission, issued a proposed rule to ban non-competition agreements. For those of you who are watching, you might think, what is a non-competition agreement? A non-competition agreement is a post-employment restrictive covenant. Post-employment, you're no longer working for the company. Restriction, you've given something away. Covenant, it's a contract. It's a deal that you strike with somebody after you're no longer there, that you're bound by. Now, we live in a society where almost every single worker is at will, which means I can fire you for any reason. It could be Tuesday. It's Tuesday. You're done. This is what we live in. We live in a world where labor is transient, but employers are not satisfied. They are not satisfied they can avoid pensions. They're not satisfied they can avoid unions. They are not satisfied until they can control you after you leave. And the FTC said, oh my God, how many people have a contract that says you can't do your job for a period of time in a geographic region? How many? 30 million. Hold on 1 second. 30 million people. 30 million Americans. Who has this? Is it all the executives? Is it all of the C-suite? No. 40% of non-competition agreements are for people making under $15 an hour. Under $15 an hour, you are locked into a contract where if you go and you do what you've learned, your former employer can sue you, and they can sue your new company, and they can bankrupt you, and they don't care. If you look at the FTC's proposed rule, 26,000 human beings and some institutions made comments, and they told the story of people who have lost their homes, lost their careers, lost their families because they weren't allowed to do their job. This is doctors and nurses and anesthesiologists. Sure, it's recruiters. Sure, it's freight brokers. This is an everybody problem. And when the rule was finally made, when the FTC finally said, we are going to ban non-competition agreements in almost every single circumstance, except for C-suite employees making over $151,164. And people who sell their businesses. Because when you buy someone's business, you buy their goodwill. You do not buy them so they can go and compete with you. Those make sense. Those are reasonable. But when you are talking about an entry-level person with a high school education or a college education who has never talked to a lawyer in their life, and you are going to make them give up 2 years of their career because some shareholder or some executive said, well, it's really hard to retain people. What should we do to retain them? Should we give them better benefits? Give them a better job? No. Let's just threaten to sue them into oblivion. When the law becomes a sword used by hiring entities to suppress wages and to limit your ability to go do your job, it is deeply un-American. So what happened? On the 23rd, the FTC issued their final rule. On the 24th, the U.S. Chamber of Commerce, among a lot of other entities that had already said they were going to sue, sued. What happens next? Is the ban going to happen? If the ban stays in place, what happens next is 120 days pass. And then every single employer who has issued a non-competition agreement has to send a memo to every worker and says, I am no longer allowed to enforce this ban on you. You can now go do whatever it is that you want to do. However, it's very clear that the U.S. Chamber of Commerce chose the district court in Texas because it's a friendly court. And ultimately, this ban will likely be enjoined. That means it'll be frozen pending litigation. It'll go through the court in the district. It'll likely, no matter who wins or loses, it will be appealed to the appellate court, the Fifth Circuit Court of Appeals. And whoever wins or loses, the loser will appeal to the Supreme Court of the United States. The Supreme Court may or may not take this case. It is up to them. They have complete discretion over what they choose to take. But because this thing impacts so many people, because it impacts so many types of businesses, it is very clear that the Supreme Court of the United States is likely to take the case. And the question really is this a major question? Does the FTC have the authority to do this? Now, we are not here today, I don't think, to talk about the authority of the FTC. Now, we certainly could. But what we are here to talk about is the post-employment restrictive covenants that are found for nearly every working American. I'll run through them briefly, and then we can start talking about these things. There are non-competes. They are a contract that says for a period of time, you cannot do this job in this area. And if you do, we sue you. Then there's a non-solicit. It says you cannot call your former customers and you cannot call your former coworkers for this period of time. If you do it during this period of time, we will sue you. Then there's a non-disparagement clause. Almost every single one of these has no time duration. It says, if you say something that hurts my feelings or my company's feelings, we will sue you. And the last one's a non-disclosure. It says, we are going to show you confidential proprietary information as a part of your role. You may not take this confidential proprietary information and disclose that to a third party other than your lawyer and maybe some other financial planners and that kind of stuff. Then you finally have a thing called a TRAP, a training repayment agreement plan, which essentially is if you are trained by your company, the company can come back at you when you leave and say, hey, give me the money that you had in training because we made you more, competitive in the market.
Otherwise known as lease purchase.
That is a form of trap. But no, we see them with dog groomers. We see them all over the place.
I just had to slide that in there, lighten it up a little bit.
I am deeply passionate about this issue because my clients that I've worked with over the years, and so many of my friends have had their lives absolutely destroyed as a result of non-competition agreements. And I am fundamentally convinced that if a business owner is saying they need non-competes to be successful, I do not think that they're being accurate. I think they're being disingenuous.
Yeah. And so I think a lot of the points that you bring there are valid points. And I think that perception has to be brought to the table in order to make a decision as a nation of how this is going to proceed. We have to be educated. And that is one of the things I love about what you do, Matthew. And much to the other side of that, I've sat on both sides of this. So I'm here to tell a different story. I'm here to tell you how in many business people that aspire to do better things, truckers who want to be trucking companies, brokers who want brokerage firms, those people are driven. They aspire for more. They're living their version of the American dream. Those people benefit from a fairly implemented non-compete. For those that are complacent, those that are okay with punching the company clock, those that are okay with working for someone else with no aspirations for anything outside of that, then yeah, non-competes aren't for you. And probably half the podcasts out there aren't for you because those are in the interest of betterment and education and furthering yourself. So I challenge you to your motives for tuning in. At the same point, they fail to attract talent. Those people that are trying to talk about non-competes. Yes, just like bad doctors, bad lawyers, bad truckers, bad recruiters, there's bad agreements. But a lot of the people that I see that really want those gone are the people that fail to develop their own talent, that fail to attract their own talent, that fail to have development and leadership in place to grow their talent. So the only way they can survive is by poaching both ideas and people.
Poaching is a non-solicitation issue. It has nothing to do with the entrepreneurism of making your own company. A non-compete stops entrepreneurism. That's the whole purpose of it.
Well, I mean, it restricts it. And if you're looking at it from a growth standpoint, if I'm a business person that's inspiring to be like the people I aspire to be at, that I learned from,
then you're legally prohibited from doing that job. That's the whole purpose.
For a time period. And that gives me 2 years to come.
2 years. That's an entire.
That gives me
lifespan.
2 years to come out the gate and be the rock star I know I can be, while I can go into another vertical and explore other educational fundamentals of the industry. So for me, we'll use me as an example. I'm a recruiter. It would be detrimental to say, hey, you cannot recruit anywhere. Nah, except that's not how it's implemented. It's often implemented as I might not be able to work for another third party, or I might not be able to go to a cross-count carrier. But what if I went into safety? What if I went into operations and I learned that business that much more over that period while formulating my business plan and then come out the gate? Now, I'm not going to argue the time periods or the applications. I don't think non-competes are bad all around. I think there are poorly implemented ones. Absolutely. And Matthew and I have had this discussion before. There are poorly implemented ones. But there's also the applications where they make sense. If I'm a business owner, I'm that trucker that finally got my trucking company, and I spend time and money investing into my people to help them grow so I can grow, because a good business takes a team. It's a village. It's not a person. You can't scale a person. Well, you can, but they're going to have a heart attack. But you can scale a business, and that takes a team. So when you're scaling a team, you have to invest into that team. Shouldn't you have some assurances that that person can't just be poached across the street and share those ideas and those talents and naturally open up a shop across the street from you and compete with you?
This is the fundamental trick that the people who love non-competes like to do. They like to try to make it sound like it's about protecting intellectual property. We have a contract that does that, called a non-disclosure. You don't need a non-compete to protect intellectual property. A non-compete is designed to stop you from doing a trade in a given geographic area. It is to starve your competitors from competition. It is to suppress wages, and it is to dissuade people from being entrepreneurs. That's the purpose of them. Now, you can disagree, but that's because you're not right. You're incorrect. I don't want to.
Well, in perception's reality, and I mean, in your reality, I might not be correct, but being somebody that's sat on the other side and being somebody that's been a business owner, I've seen both sides from both. Let's talk about
businesses and why people quit. All right, you leave an industry either because you hate the industry or you don't like the people you work for. You may love
not necessarily. I quit a job because I outgrew it and I don't want to.
You may love the industry, but you are legally prohibited from staying in it. You take a driver recruiter, pay them $30 or $40, maybe $50,000 a year. You tell them they can't do that job at all for the next 18 months or 24 months.
Well, it's not enforceable at that point.
Oh, people try.
Not at all. Not at all. If you work for a carrier, you can go work for a third party. And if you work for a third party, you can go work for a carrier. What you can't do is go across the street, open up your own shop, and then use everything that I've invested into you to compete with me, because that's a conflict.
The idea about the investment into the employee. Now, we are all business people at some level. As a business person, we make more off of the people and the people get from us. If we lost money as a business, we wouldn't be in business very long, or we'd be Convoy or a tech company. But if we're real companies, we're real businesses, we are extracting value from the work of our laborers, and we give back with benefits and PTO and all this other stuff
and growth.
The idea that you can take somebody and say, whatever you've learned here, you can't take it. That's fine. That's a non-disclosure. If you met customers or drivers, you can't solicit them. That's a non-solicit. The idea that you would say to somebody, you cannot do this role for yourself or for a competitor. The only purpose of that is to keep wages low and to stop competition. That's why they're called non-competition agreements. The idea that you would date somebody, let's use dating as an example, and you say, hey, we're an at-will relationship. We're an at-will relationship. We're an at-will relationship. Charles, okay, so without a time period, geographic region defined, then the non-compete is not worth paper it's on. That is
much to my point. It's not enforceable.
Let me back up. That is not accurate. Bill, I like you. I love you. That is not accurate. Many non-competitions are bound with a thing called blue penciling statutes or blue penciling in common law. What that means, and TQL knows what blue penciling means. If you write a non-competition agreement and you make a mistake, you make it too broad, you don't make it enough wiggle room or whatever, the court can rewrite that non-competition agreement to make it enforceable. And literally every single non-compete that I have ever seen has what they call the savings clause. And the savings clause says, if by some miracle or some absent thing that happens, we made a mistake, it's not enforceable, make it enforceable. States like Illinois have made special carve-outs that make the non-compete completely void. If you don't give someone 14 days to review it, for example, it's void. But if you make a mistake with time period geography, or you make it too expansive, it's a 10-year non-compete, courts can and do remake them. Now, how much does it cost to litigate a non-compete? $10,000 to $20,000 a month out of your personal money. People do not litigate. They get default judgments. They move. They change jobs. If anyone who's watching this reads a single comment on the FTC's website about all of these things that have happened, that is how it plays out. That is how it plays out. Now, people say, oh, we don't always enforce the non-competes. Most non-competes are given after someone has accepted the job. They don't know there's a non-compete. I think a law should be, FTC, if you're listening, I hope you are, if you get your rule knocked down, force every single employer to disclose on every job opportunity that the non-compete is part of it.
I agree with you fully there,
100%.
but now I'm going to piggyback off that point just because you made a valid point, and I want to elaborate on this. We talked about the people, most people aspiring. I don't know many people that don't aspire for greater things. So if you're aspiring for greater things, I challenge you to read before signing. It's just like all those people that opt into apps and don't read. Like, who doesn't read what they're signing?
Yeah.
And at that point, the only person you get to point the finger at is yourself.
All right. I want to take a stab at this personal responsibility argument. Let me be very clear. That is a strong argument, and I agree with it. It is absolute bullshit. It is absolute bullshit. Most people are given 4 or 5 days to review a non-compete. Look, I have papers on my wall. I am still paying for those papers on my wall to read contracts. If you are going to give somebody a non-competition agreement and you're not going to pay them or subsidize them to go get a lawyer, why should someone have to spend $500 to get a lawyer to review a non-competition agreement? Because I'm telling you, most people are dumb as rocks when it comes to the law. I was trained in it. My brethren and sisters in the legal profession were trained to read these things. If you are telling somebody it's your own personal responsibility, and that is absolutely part of the argument the U.S. Chamber of Commerce is advancing. People make decisions all the time. You are not giving them the requisite resources to do that. And similarly, if people really want to protect non-competition agreements, pay the person during their waiting period. That's what executives get. I mean, people don't realize this. If you're a C-suite person, you have a non-compete, they are going to pay you to sit out for a year. I guarantee you, the vast majority of non-competes, no one will pay you because the businesses can't afford it. They can't afford it.
So that goes to a whole nother point, though. And so we're talking non-competes broad spectrum. Yes, we're for them. No, we're not. And who are they for and who are they not? I do think that the argument can be made in there, just like bad doctors, bad lawyers, that there's bad non-competes. And it's your personal responsibility to sit there and do your due diligence. Because if someone is presenting you with a bad deal, turn it down. You have the right to turn it down. Or even more, I encourage people to do this more because I've done it. Matthew, you've been involved when I've done it. I encourage people to open up a discussion on what they don't like, what they do like, and negotiate those terms. You know how many people do not do that?
90% do not.
How can you not be your own advocate?
It goes back, Charles. This is the thing that bothers me about this. I get passionate, but I want to just make sure people understand, like, this will be my son or my daughter, my brother or my sister, my mom or my dad, who's going to be given a document that they absolutely are not qualified to read or understand. Again, these are at-will employment relationships. No separate consideration, additional money, additional PTO, additional anything is given in exchange for this thing. People give up rights without understanding they even had them to begin with. And if you are asking someone to look at a document and make choices to try to negotiate, not a single high school or college is training people how to negotiate non-competition agreements. They're just not doing it. And yet this is 30 million people. 30 million. I look at the Jimmy John's case. Like, let's just see how absurd these things are. Jimmy John's forced their workers to sign a 2-year-long non-competition agreement. It said if you were working at a sandwich shop within 3 miles of one of their locations, you could be sued. Now, New York and Illinois both sued Jimmy John's, and they retracted them. They said, we're not going to enforce them. But it goes to show that these things are pervasive. They are ubiquitous, and they are not good for American workers or for shareholders. If the only reason you have retained somebody is because they're too scared of being sued by you, they spent 10 years in their career and they want to leave and go do it somewhere else and have to sit out for a year or 2 years, that is asking far, far too much of our American compatriots. We don't want to do that.
Now, I want to look at the other side of that because there are perks to a non-compete. There are things that give the business assurances that they can now invest into their people. I am less likely, and when I say I don't mean me personally, I'm going to invest in my people. If I'm hiring you, I'm investing in you. But as a business, You are more likely to invest in your people if you have some securities. And that's where that non-compete comes in, that I'm not investing in someone that's going to go work for my competitor and use that. My competitor is not going to use my training to further their agenda, or that person I'm investing time and money in from my blood, sweat, and tears as I bootstrap a business, which a lot of people do when they're aspiring to build. And hey, anyone that's built a business in this room, you've bootstrapped, you've worked your blood, sweat, tears, personal money, and finances to build that. There's nothing worse than investing into somebody and watching your competitor poach them because they had a bad day. And we see it. Anyone that's worked in the HR side of things has seen people leave on a bad day. There are predatory companies out there that wait for you to have a bad day, and their little drip marketing ropes you in and hooks you on that bad day. And then that person comes back 2 or 3 months later, but the damage has already been done. So as a business, it is harder to invest in the training and development when you don't have those assurances. Now, I'm not talking those obscure examples like Jimmy John's, like, hey, listen, it's a sandwich shop. Like at a certain point, there has to be a line in the sand. And that's where people need to be their own advocate. And it's something you guys have heard me say in our past discussions. Matthew and I have had this discussion. I think people need to be their own advocate. You want to be treated like someone that's aspiring to grow, then you should act like it. And you should ask questions. You should promote discussions. It goes along the same lines as people that accept a job, and then on Friday they accept a job, and on Monday they don't show up for the job. Like, what adult does that? Have a conversation.
I just so I want to just interject before I forget a point on this, and then I want to ask a question for both of you. I got 2 questions actually.
Yeah.
So here's a big issue with that I have. Matt and I talked about another one, but is let's just say you're in someone like my position, or anyone that's been in this industry a while. You've worked your way up. You started as a dispatcher, you moved up to this position, and then you finally get like the director of transportation. You know what I mean? Right below the sea level. You've worked your ass off for this 15, 20 years. But when you take that job with whoever, you sign a non-compete or something, you can't work in this thing. And it's like, boom, all of the stuff that I work for. No, it's not gone away, but now I've got to adjust, probably take a pay cut and do something. And that's my thing, is like, I understand like your point, Charles, because personally, I do get that, I'll use the military as an example. Not that they make you sign non-competes, but I forget what the number was, but it takes several $1 million to put one soldier through boot camp, like millions, with all the food, the clothing, the training, everything. One soldier for 9 fucking weeks. And, so I get it. Like, you can invest a lot of money in someone, especially if we use the example that I just gave, if that person's been with you for that 15 or 20 years, you know what I mean? So I get that. But again, I just, to me, it's, in a way it's un-American. It's you preventing someone else for carving their path and using all the stuff they got. Yeah, maybe you offered some training to them or whatever, but they did it. They learned it. They taught it to themselves. They should be able to use that skill. That's that point. Y'all both already have said the rebuttal to that. So here's my first question. Do either one of you agree with, or what is your word on, say, a short non-compete? Most of them, yes. I think, what's the shortest, a year? But I've
seen 3 months.
I have a 3-month non-compete, and I'll tell you the reason I think those are valuable is and Matt, I'll cut you off on this one. I'll apologize, but I'm passionate about this, and you and I have worked on this together. A 3-month non-compete for a position, especially an entry-level position, still protects the employer where they can have those investments. And if you're not developing enough where that provides you assurances, then you're probably doing business wrong in the first place. 3 months is a safe one for me. I am all for a short-term one. I think those longer ones should be reserved for the higher salaries. I agree with that notion. And even the FTC said, hey, certain threshold, certain level, yes, they make sense. Selling a business makes sense. But we'll use the example, a recruiter or a broker, 3 months, if a business can't have securities off 3 months of a non-compete, then you're doing things wrong in the first place, and it's time to be better.
I would also agree with a 3-month non-compete in the vast majority of applications, if we have to live with these things. Now, what I would recommend, I'm much broader in this stuff. you should have to pay the worker to be able to get a lawyer to review it. You should not let a non-lawyer, because I guarantee Charles and his team have lawyers that have vetted those contracts. Like, I guarantee. So the reality is you should have the same ability to access legal counsel when you're signing away your rights. If you're going to give your rights to the corporation, which is exactly what a non-compete is, you should have the ability to with counsel, probably a 14-day window at a minimum to review the document, with a stipend that pays for the lawyer, maybe $500 or something like that, which can be paid in a disbursement later on, like travel expenses. And you should also force the employer to pay that person for that 3 months. Like,
you should talk.
I mean,
you should have a conversation. We've talked about this. I mean, people need to have conversations. And if you're applying for a job and they're not willing to have a conversation, to do yourself a favor and turn your back and walk away.
I think that this is where we get back to this idea is like, do people know how to ask for these things? Most of, like, I was talking to Pedro and Freighthound about this earlier. Is like, for me, what I do is I try to tell people what these documents are. My entire social media outreach, more than anything, is this issue. Because someday your family will be faced with this.
Wait, you have a day job outside of this?
I have many things. I love trailers. But the thing is that when you're in this situation, is it better to start with a fair table and say, okay, it's going to be 3 months. We'll pay for your lawyer. It's 14 days to review. And when you leave, or when we let you go, we'll pay you for 3 months to keep you off the market, or waive it, whatever. I just don't like this idea. The dating analogy makes a lot of sense. If you're dating somebody and you're at will, you can leave at any time. You can always walk away. And then your partner says, hey, we got to go our separate ways. But if you see anybody else like me, anyone else with glasses and a beard, I'm going to sue you. And I'm going to put you into legal jeopardy. I'm gonna get an injunction against you. That's absurd. Like, we'd say that's a very controlling guy or gal. Like, that's really controlling. But we come to our employers, we say, what have we watched in the last 50 years? Wages stagnate. The right to work everywhere. Everyone's at will. There's no for cause only terminations, absent like very specialized jobs. And our employers, our hiring entities, take more and more and more, and they act indignant when you say, I don't like these anymore. To the FTC's argument, ultimately, this lawsuit by the Chamber of Commerce will win. It'll win.
I want to say, I'll say one thing, then I'll ask my second question. So if there was anyone that I could see handing their spouse or their to-be girlfriend a contract, on a funny note, it would be you, Matt. Could you see Matt? Sign here, initial there, initial there.
And don't forget this little arrow sticker right here.
I am very, very blessed with an amazing spouse who tolerates all sorts of things that I do.
I think when you operate at the level you do or I do, you have to, they're working on sainthood in the background, Matt.
Oh, absolutely.
All right, so my next question was, and again, Matt, we talked about this backstage. I've never been victim to one of these, you know what I mean? So I've been fortunate, so I don't know, how extensive they can be. But is there a thing, do y'all see, or what do you think about one that with like kind of like, I guess we'll use the military for an example. Hey, you come to work here, here's this non-compete, but if you give us X amount of time as an employee, we rip this thing up and it doesn't mean anything because, we feel we've gotten our money. Does that exist out there?
It makes sense in concept, but the problem is generally with time comes experience and money. So a lot of and I saw your face and I figured that's exactly where you're going. It's the
opposite. It's the opposite. If you've been there for a short time, those non-competes are very likely not to be enforceable. If you're under 2 years, the courts will be like, go away. Yeah. But the reality is people receive that cease and desist letter, and that's the end. They give up.
I have pro bono Matt in the house.
I have seen, this is the thing people don't realize. I have seen non-competes from just about any organization you can imagine that uses non-competitions. Yeah. I don't talk about it because I have an attorney-client privilege. It's not my thing to talk about, but I know who you are. I know who everyone who uses these things are, and I understand why you do it. I understand, like, look, let me put my employer hat on for a minute. The most dangerous thing to an employer is a bad employee. or a good employee or any employee. If it wasn't for employees and vendors and customers, owning a business would be amazing. It'd be a great experience. It'd be amazing. But
automation, Matt,
it's coming. The robots are here. They're not too far away.
Non-competes are gone at that point.
Well, so we put people in boxes. Like there's lawyers who spend thousands of hours crafting a non-compete, knowing that it's right on the edge of being enforceable. And they send that letter to you, they send to your new employer. And what they do to your employer, your new employer, they don't send a letter saying, hey, your guy is breaking a non-compete. They say, you are tortiously interfering with our contract. We will sue you as well. So this is the reality, is that this is a way to, again, fight your competitors using the legal system. And it is ubiquitous. It's everywhere. And it's not appropriate in the vast majority of cases. But they're here to stay until Congress makes a rule.
And the thing is much to your point, like, yeah, it's going to get knocked down with these lawsuits. There's enough arguments behind it. I think the best case scenario out of here from an employer and employee standpoint is for a little bit of attention to the outrageous ones, a little bit of guidance out there to what these should look like, some restrictions to what they shouldn't look like. Those things, in my opinion, and I'm never one to advocate for any government. Anytime the government's touched anything, it's gotten worse. But I do think just some guidance, and much to what I do and much to what Matthew does and what you guys are doing right now. I think education's a key piece to this, is educating people so they can see both sides and form an opinion. And one of the things I will leave people with is educate yourself. Pay attention to what you're signing. Don't be scared to have a discussion. Don't be scared to have that conversation with a potential employer. Ask those questions before signing. It's kind of a moot point after you signed and 2 years later you revisit back to it. You should have these conversations up front. And much like the dating analogy, if you don't like the answers, walk away. There's tons of other options out there. They might not be the one that you're looking at that moment, but there's tons of other options. You will find the right one. And for me personally, as an employer, I'm open to having those conversations. I'm open to having those discussions. I've proven it in the past. But you have to be willing to ask those questions. You have to be willing to have those discussions, whether you're the employee or the employer. Those things matter. You're forming a relationship. Part of a relationship is conversations. If you can't have those, then it's probably not a match.
I want to see non-competes go away. For people that are watching or listening, there's so much more that you can do.
I don't think there was any confusion there about you and where you stand with non-competes, Matt.
There's a thing.
I'm pretty sure it's assumed when you walk in the room, your standpoint on this.
The Workforce Mobility Act is currently in Congress. It's bipartisan legislation. It's been stuck in committee for some time. The chamber talks about that in their lawsuit. The reality is, like, it's up to you as Americans if you care about this issue. If you care about entrepreneurism, if you care about diversity, equity, and inclusion, if you care about the things about advancing yourself and getting to a better place in your life, you have to fight these things. Non-competes at their core is about removing rungs of the ladder so that people behind you can't follow you. That's the point. And again, I get passionate because these are deeply unfair contracts given to people who do not have the means to address them. If you go to most Americans and say, I need $400 in the next 24 hours, there is at least half of America that could not get you that $400. That should make all of us go, wait a second. You're going to offer somebody a job. They're going to accept the job. They're going to walk in day one and be presented with a 10-page document. And it'll be said, sign this or you're fired. Or even worse, you've worked at the job for 12 months and then some change of control happens and you get a knock on your desk or right at your cubicle and says, hey, just so you know, we now have to sign this. If you don't sign it, you're gone. You're fired. And you say, I don't know what to do. Well, you're out of luck because that's the rule we live in. That's how this is designed. We have not built this system to be accessible. We've not built this system to benefit you. There's a very specific group of people who benefit from non-competition agreements. And the best advice Charles gave is don't sign them. Don't sign them. The government
don't sign them and without doing your research. You're going to force me to a Zin break.
You're
going to force me to a Zin break.
I have never in my career as being a lawyer since 2010 met a single person other than a business owner who sold the business and had a 5-year non-compete. I have never met a single person that says,
sounds like
man,
to do a better negotiation.
Signing that non-compete was the best thing that I ever did. No one says that. No one says that.
So I'm going to tag in. I got my Zen kick. I'm ready. All right. So I want to offer a different perspective here. All right. You heard me early on talk about people that aspire to do more. Well, imagine being that person that aspires to do more and you doing it. And that blood, sweat, and tears. How many people in here have built something from the ground up? Show of hands. All right. Cool. So we're all on a level playing field. You remember the bootstrapping days?
They're always bootstrapping days, buddy. This doesn't get easier. It's just a different level of problems.
It does, but you usually start with something small. I mean, like, I'll speak from my experience. I remember trading in $150K a year to go work out of my garage, and my wife thinking I was nuts. And I took $1,000 of my own cash out of my personal account, put it in a business account, and that's what I started with. And as that multiplies, as that grows, you're strategically placing each piece on the board and strategically making your moves. And eventually, one of those moves is growth. You need help. You can't scale a person. You have to scale a business. So when scaling a business, you have to have the right people. So part of growing, especially as a new business owner, we've all been there. Anyone that raised their hand, put them up again, because we've all had a bad hire. And when you have that bad hire, you learn. Well, part of that learning process is also learning that how do you protect yourself in situations like that? So those people that aspire, those people out there that want to do more, those brokers that want brokerages, those truckers that want trucking companies, eventually you're going to cross this bridge and you're going to have to make a choice. And when you make that choice, you're going to be looking at it from a different perspective. I encourage you to evaluate that perspective now and start thinking of how you want to do it, because it's going to change over time and it's going to be very enlightening to look back at it. But I will tell you that the people that are looking to live the American dream, part of that American dream is some level of protection. If you build something, you want to have that protection. The only people that are completely against non-competes are the ones that don't aspire, that are okay with punching the clock, that don't want to build something of their own. Those are the people that are completely against them in all facets of business. They do have an application if properly applied. And that's where I encourage people to do your due diligence, have those conversations. You have people, you have assets out there. Not only do you have educational material out there, you have people like Matthew, you have people like myself that will give it to you, that have no dog in the fight. I have no dog in the fight. I don't care. I'm open to a conversation. I'm willing to bend for the right people. I think more employers should be like that. But at the same point, I want people to have the information and learn, because I've stepped on the landmine. I've made those mistakes and they hurt. When you blow your leg off, it's hard to forget. At the same time, you have people that you've helped. So I think there's arguments to be made at both sides, and people have to evaluate this from their perspective and an application that matters to them. And it's not a cookie cutter. It's not your way or my way. It's usually somewhere in the middle, and that is life. That is the American dream.
We need to get away from this mentality that businesses are fragile, that, oh my gosh, I've hired a bad employee and this is a disaster for my company. But God forbid they go work for a competitor and steal one or two of my big customers. If the only way you can,
that's a different conversation.
The idea of making taking someone away from just competing at all. So the thing about this is the great thing about non-solicitation. Let me back up for a second. Non-solicitation agreements stop you from calling on the customer. It doesn't stop the customer and the people. It doesn't stop the customer or the people
calling upon
you.
Exactly. So do your job right. Have them come to you.
If you have a non-compete, they can't call you. If you have a non-compete, you can't work.
If you do your non-compete right. We talked about this earlier. If you do your non-compete right. And
if you're afraid,
I've done this. I'm about to lay out my whole thing. All right. I'm going to expose myself for you. I have one. All right. And I'll tell you, I've had this conversation with my lawyer and attorneys and family. And I'll tell you, it was a hard one for me. It was.
You sold a business, Charles. Your non-compete is legitimate. No one's
no. You don't know you do not know all the details on mine. What I will tell you is it was and it wasn't the first one I've ever signed. It was a very controversial moment for me because I had to make a choice and I had to formulate a plan. And those people that aspire to do great things generally think like this. So I planned out. And I planned out what it's going to look like when I exit. One of the wisest lessons someone ever gave me is always have an exit strategy, even when You don't need one. That's how that works. So my exit strategy at the time that I signed one was, hey, what would I do if I needed to leave? And they enforce this. Okay, cool. Well, I'm going to go here. I'm going to do this. I'm going to do this. I'm going to further myself as a person. And that gave me, at that time, it was only a 1-year non-compete. It gave me 1 year to plan my ultimate out the gate, what I was going to reveal, hence hot seat services. And I'll tell you, the success story that came from that is where I sit now. If you think about it, if you have those conversations, if you're honest with yourself, they might not be for everyone. I absolutely do not agree with them being applied to Jimmy John's, McDonald's, truck drivers, entry-level positions in general. I do not think. But as someone grows, as positions change, as education and development get implemented, yes, I do believe that the employer should have a level of protection. And that level of protection does come at the cost currently of a non-compete. But also, if you're smart and you're aspiring to be that business person, you're aspiring to be that trucking company or that brokerage firm, negotiate. Don't take it for nothing. And if they say no, then walk away. It probably wasn't a good fit. It was probably going to be ugly in the beginning. It's just like speed dating. You ask a couple questions, you don't get the right answer, you move on to the next. It's okay to say no. And I think a lot of people have forgotten they have that ability. Say no, walk away. Do your research, ask those questions, leverage your network. You have people like myself, you have people like Matthew. You can get it from both sides of the spectrum. And if you're coming to us and you're not directly involved, you're going to get a no dog in the fight approach from both. And besides Matthew, besides myself, there's hundreds of other people you can use, even if not one of us.
I just want to push back on the idea that people have the resources to get legal advice. I would never encourage anybody to get advice on a legal document from a non-attorney. That's a terrible, terrible idea. I think people should have the time and the money to consult an attorney to get review of something that is giving up their liberty. Because that's, again, function what's happening. We talk about protection.
Protecting that legal market share there, right?
I don't want like legal fees for non-competes. I want them to go away. We talk about protecting the business. The idea that the business is so fragile. My value proposition to my customer is the fact that all my employees are restricted from competing with me. That's bananas. What protection do workers have? What protections are they given? If you're not going to pay them to sit.
So do you work with companies that have non-competes? Do you have clients that have non-competes?
No, I don't.
Not a single client you work
Absolutely
with has
not.
a non-compete.
I wouldn't. This is the thing
That's
about
part of the dating process. I'm not talking about the law firm. I'm talking about business in general.
The thing about non-competes is that when you use
did not answer that, by the way.
I don't know. For non-legal clients, I don't get access to their documents. I would never ask them for contracts that they use. I know the ones that I work with, like I know who has non-competes, and I avoid those companies. But the fundamental thing at this issue is that we as Americans have slept on non-competes for decades. They have been a tactic used by employers to suppress wages, kill entrepreneurship, and ultimately are bad for shareholders. If you are saying to some
suppress wages, I've heard you say that. How do they suppress? Because I'll tell you, in my
how do people make money in this day and age? You change jobs. If you stay at a company your entire career, you might get a 3% increase every year. That is how it works. The only way in America that you can get good wages over time is changing jobs every few years. That is absolutely fundamentally the case in the system. Now, whether it's good or bad, I don't know, nor do I care. But that is how you make more money, is changing jobs.
Though. There's plenty of applications where you look at plenty of the LinkedIn resumes where someone has spent 30 years at one company and moved up, and at some point they got hit with a non-compete. I mean, one comes off to the top of my mind. They're not here, so I'm not going to say their name, but I did my research before walking on because they were going to be an example if needed. This particular person started off as a store clerk, and now they're the COO of a company. There's another person that started off in the broker office, and now they're the executive vice president of a multi-million-dollar company. At some point, you imagine, and I think you can acknowledge, at some point someone hit them with a non-compete because they're investing into this person over time. Now, I do not think, by no means am I saying the entry-level workers should have these. I actually disagree strongly with them. Or I think
would you support a congressional ban for people at a certain dollar amount or certain, place within their organization?
I think that's actually mute, because if you look at each business, and the reason I say this is, hear me out, each business is laid out differently, especially those ones starting up. Maybe there's a 5-person company out there and that one person wears 5 hats. That would be detrimental for that person to go across. Now, granted, that business should eventually diversify and having more people in that position, but that's a whole different topic. We all grow from somewhere. I think that there is a level, and I don't think there's a cookie cutter mold, much like many things in this world. There's not a cookie cutter mold to fix it. I think people need to do research and align themselves with people that are like-minded, with like-minded goals, that respect what they're trying to achieve. And I think that comes from the interview process. If I'm interviewing someone, I want to know where they want to be in 5 years. And that way I can attribute that to that development and growth, because that they grow, I grow.
Would you support a rule around the FTC that required disclosing the non-compete before
Absolutely.
someone? Okay.
Absolutely. I
Yeah,
want it out there on the front. I want you to know about it. Actually, and again, how we first met. I'm not going to go into the particulars, but the way we first met was on this issue.
That's
and
right.
We sat there on the phone, talked about it. And I think we can both relate that it was a conversation, and it changed to what meant that it was going to be valuable to both sides. And that's where I think these conversations need to take place.
What I'm excited about is we're talking about this animal called a post-employment restrictive covenant. It's a perk. That's how you abbreviate as perk. And they're not necessarily perks, but that's what they're called.
I wonder who figured that name out. And then,
but we need to understand what is being asked of us. And what the FTC rulemaking has shown us is that Americans are very much engaged with this topic and understanding what you're signing before you sign it. We have as Americans, and everyone, I think, so used to just agreeing to the policies that AT&T puts you. You're not going to negotiate with AT&T. They're just going to accept it, or you're not going to.
I encourage it. It's fun.
People can insert all sorts of things, and there's been litigation around people inserting really interesting random things. But beyond all of this, I'm very excited that we're talking about this topic. And the Chamber of Commerce understands ultimately that the trends and forces in history are to remove these things. They will go. If you look at every single state in this country over the last decade or two, they have made more and more restrictions on non-competition agreements. So the FTC ban may not ultimately be successful, but that momentum is not slowing down. And the more we can talk about this thing and understand what is being asked of us and teach our young people how to negotiate, how to say no, how to walk away, that is
teaching them to change the oil. You should teach them. I did with my son. I have these conversations all the time. When I have these learning moments, I have these conversations. And much to your point, I would actually love, in a perfect world, as an immediate fix, I would love a bright yellow disclaimer, like very short sentence saying you are signing away this for this, read above, with a big arrow highlighting, maybe a neon light that they can put over it.
That's what Illinois did. I mean, for the folks who are on this listen, so Illinois makes a rule that you have to give someone 14 days. There's a salary requirement too. And there's also a part in the contract that is all caps that says you must consult an attorney if you have a right to find an attorney, all this kind of stuff. Those are helpful, but ultimately people still sign these things, not necessarily understanding, because again, they're not lawyers. They're just told, oh, it's a non-disclosure agreement, but there's this little clause on page 8.
What someone says and what's written on paper are two different things. Do your diligence, be your own advocate. It's like everything else. Would you tell your kids to go out there and sign something without reading it thoroughly?
That's why I'm an attorney. You see, not many people have parents that are lawyers, and it's unfair. Deeply unfair that my family has access to an attorney whenever they need to, and the vast majority of Americans don't. And it's nice to see the FTC taking a firm stance that these things are not good for America. They are deeply un-American. But I understand the idea as you want to build a moat. As a business owner, your job is not
to protect your business and protect its growth, because people have jobs and access to jobs as businesses grow. And if you're smart, and I will give this free tidbit, and it's going to come back and probably kick me in the ass here in the next couple of months because I'm doing it on your show, and I'll remind you of that moment. If you're signing a non-compete, you should use it as a negotiating factor. If you're asking me to sign this, then hey, what are you going to give me in return? It never hurts to have a conversation.
I did a very well received green eggs and ham parody on non-competes and how to negotiate those things. So I got to get close to the hour. My hope for everybody is that you share my passion that these things, for the vast majority of people, are not fair. You sign them and are given no legal resources to get someone to review it. You sign them with no separate consideration, no bonus, no stock, no equity, nor PTO, no extra compensation. You are given these as contracts of adhesion, which is to say you're generally dissuaded from negotiating. And if you do negotiate, most employers will just say, go pound sand. And then you're also given these things when you're, making under 15 or under $20 an hour. And it happens to every single industry. It's not just freight. We talk about in freight because that's what we all do, but it's in everything. It's the reason why doctors leave rural communities is because they can't work in the same geographic area as the hospital that they're currently working at. They have a 30-mile radius and there's no other towns around there. You want to understand the medical problems we have in the United States? It is a result of non-competition agreements. These things are pernicious in every single industry. And if you're making a bad medical decision because people aren't available, that's bonkers. We see them in the C-suite. We see them selling a business. I don't lose sleep over C-suite or people who sell businesses. I do worry about that low level, that medium level person who now cannot do what they've trained to do. Lawyers are generally not bound by non-competes. We are smart in the sense we don't allow them in our industry. We fight for them to not be a part of it. And they can certainly happen in some cases, but they're not available for the vast majority of lawyers. We are aberrations. Everyone else, 1 in 5 of you who are watching this, you're bound by a non-compete, and the government is not going to come and save you. Your employer is not going to let you relent. It is up to you when you finally decide to leave to never sign it again. Do not sign that non-compete. This is not legal advice. Don't take legal advice from a television show or a podcast.
A nice disclaimer.
But you should consult an attorney. Don't sign them. You're going to be very, very regretful if you do.
And I encourage people to read. How many people download an app and don't check the box and don't read it? How many people get mad when they buy a car and then drive down the block and they didn't do their research and they found the same car with everything? Can you blame anyone but yourself? No. So do your research. Be your own advocate. You can always ask for everyone else to solve your problems, but be your own advocate and try to solve some of your own by doing your own research and educating yourself. It's only going to further you as a person. And for those that aspire to do bigger things, this is one of the ways that you do it. You educate yourself, you build up your knowledge, and you use it.
I don't like non-competition. I don't like those contracts.
All right, hold on. Can we poll the audience how many people actually believe he likes non-competitions?
Dude, I could make a whole career enforcing those things, and I don't want to do that.
See, the Attitude Roadside, my guy. I only own red pens for contracts. Absolutely. Be your own advocate, my guy. I love you.
Do not get him started. Oh my gosh.
I love Attitude Roadside. He's a good dude. He's a very good dude.
He is. Corey's amazing, man. He is. Yeah, he's a stellar guy.
I never know if I use their real names, if I use the things, their hashtag names or whatever their handles are.
You're on Logistics Lounge. It's no holds barred.
If you don't,
call whatever you want.
We come with bourbon.
Unless you tell me not to use your government name, when I find it out, I'm going to use it. You know what I mean?
I think that boat sailed a long time when they started handing out pens with my cell phone number on them.
Yeah. The only person I'm not sure if we're all actually saying their government name is Trey Griggs.
It's not Trey. His first name is different. That is true.
See, there you go. Boom.
I think it's Glenn. Glenn. I'm pretty sure.
Oh, that's funny.
I would Trey. It's a good dude.
I wouldn't do that to him.
To Charles's point, there are so many companies that have started as a result of people who have a non-competition agreement, who have to go make a new business and they have to start from scratch. There's a lot of people who can do that, but there's a lot of people who shouldn't have to do that. And if you're a high school educator, you're college educated and you're fresh off from school and you're given these things, you don't know what you're doing. You don't know what you're getting into. And even though many companies will not litigate these things, what happens? Let me tell you what happens when we go after you. What we do is we send you a cease and desist letter first to you and to your new company. And we tell both of them, and if you don't comply and respond to this letter in the next 7 days, let's say, we will file an injunction against you in court. We will seek a declaratory judgment and get an injunction. They then file the lawsuit. You are served process. A sheriff finds you personally and hands you a document that says you have been served. Now you have to go to court. You don't know what you're doing. You generally cannot do this pro se, which is by yourself. You have to go find a lawyer. You're paying thousands of dollars. You may be litigating in several different states if you've been working in different markets, because these things are written to be nationwide more often than not. Sometimes they're just by the state, but they're very often nationwide. And you are then fighting in litigation without any money coming in because your new company that just hired you, they fired you already. Like they receive this document, they see this document, you're fired. They're not going to indemnify you. They're not going to protect you. And you see these comments on the FTC's rulemaking that walks people through this experience of being sued. Talk to there's a bunch of freight brokers I know who have successful businesses today, but not long ago were in litigation for non-competition agreements. They're really, really bad.
But how many of those how many brokers are out there that built their businesses off the back of others? Poached the people, poached the businesses, poached all the ways they do business, and then opened up right across the street. So I mean, you're
looking at it from the wrong perspective. Look at it from the perspective of the worker. I may love the industry,
but what about that
worker
that built something? What about that worker that at one point was the worker and aspired, spent all of their career working up to becoming the business owner? And then now this business owner that finally
that's
got what
the
they
risk
wanted.
of having a company. You can't use the law to protect you from competition. That's the fundamental thing. Is we think businesses are these like super strong, powerful
ethical competition. Ethical competition.
There's nothing on that. A non-competition agreement is deeply unethical. You are giving away something for nothing. You get nothing from a non-competition agreement. All you do.
You know who gets nothing from the non-competition agreement? Those that don't aspire to build anything, that are okay with punching the clock. Those that want to build something, those that want to open up their own trucking company, those that want to open up their own brokerage, they gain something. They gain protection for what
fundamentally, you watch your boss's business and you say, I can do it better. I see how they're messed up. Let me go do it better. But no. I don't want to have any competition. You've signed the document. I will sue you. This is the reality.
But if you aspire, then do your research and your homework and read, and then don't.
All right, I just want to chime in. All right, so we're talking about 30 million people here. What percentage of those people are like, all right, I fucking love freight, I'm gonna go start my business tomorrow? What percentage of people are actually doing that? Because like with Matt's point here, because I signed a non-compete with TQL back in the day. And, I was there for, 8 months, a year. And I said, fuck you. Like, I'm going to go and work for another company. But I'm not out here poaching, TQL's $4 billion business, Like, that's like, dude, there's so much freight out here. There's so much business. But, like, someone that has been working for a company for 10 years and, and they love it. And it's, mom pop style and they sell out, or the CEO changes and they hate it. They hate it. And they're pinheld and they can't go to another company because this guy that walks in that knows nothing about the business, knows nothing about the industry is like, oh, well, these are my customers. But, they've been sitting here for, 2 months with their thumb up their ass. And then like, how is that competition though? Like, I get the aspiring thing, but
out of the mix, you have those oddities. And much to your point of how many of them don't want to, but
that's
those obscure ones
the
like
norm,
Jimmy John's
Charles.
and that. But it's not. I've seen plenty of well-executed ones where people have benefited from them. There's nothing more beneficial than the person having that conversation and then negotiating. Hey, like I did it with my 1-year one. I negotiated where I was going to be paid for that year. If you're going to pay me for that year, I'll sit on the shelf and do something else.
Again, the vast majority of people, except for the sale of a business or being a C-suite, will ever be paid to sit. That will never happen. So
I had one in my 1-year agreement, and I wasn't an owner selling the business at that point.
That they would pay you for a year to sit?
I negotiated. If you want to enforce this, you're going to pay me. Otherwise, it was going to be so locationally built that it was literally only if I didn't want to get paid, then all I had to do was work outside of that town. If I wanted to work inside that town in that same position or at that same caliber, then I was not going to be paid.
To answer the question about the TQL analogy, what happens is you want to leave and go work for a competitor because the grass looks greener. That's what it is. The grass looks greener, and you were just prohibited from doing that. And if you do go to the grass is greener kind of side, that's when you can get in trouble. So the reality is like it's designed to drive retention to an extent. Say, I don't want to leave because I might get sued, and you give up every bit of experience that you have. Like you can't just go restart your career. I've been fortunate. I've restarted my career multiple times in my career, but the reality is most people don't want or deserve to have that happen to them. But that's the vast majority of these 30 million people. They're not trying to go start a business. They're just trying to get by and maybe get a raise of 10%.
What was that stat you gave us in the beginning? It was 30% of people are affected by this, right?
1 in 5. It is 20% of all Americans. 30 million Americans.
4 in 5 aren't. So when we say vast majority, we got to put that in perspective. The people that are affected by it are paying attention to it. And yes, their voice should be heard. But I also, again, employ them to go out there and have those conversations, do their due diligence. It's just like with buying a car. You're not going to go blame the dealership that you found a better deal down the street and you can't go get it because you already left a lot with the car. Do your research. Be your own.
Move to California. They ban the non-competes. They can't be enforced there. There's ways around this.
All right. One, I'm not a lawyer, so I don't have to give that disclaimer. But as someone that was stationed in California, do not move to California.
I mean, this is the challenge we run into. Is it again? It has to do with approaching somebody who doesn't have the legal experience to sign a document that they don't understand for a period of time is going to restrict them from doing what they know how to do, and it is pernicious, and it's in every single industry. And at the end of the day, it dissuades people from either making their own companies or from going off and working for a competitor. That's why they're called non-competes. It is designed to protect the business, and businesses have plenty of protection already. And if you are so concerned that a rogue employee will destroy the value of your corporation, your company's far more fragile than you give it credit for. That's why I fundamentally believe they're only applicable for sale of a business and senior leaders, and anything beneath that, they should be challenged and they should be bound to be invalidated. And the FTC's ban does that if it stands. We don't know yet if it will stand, but we'll be watching that for the next few months, maybe years.
I agree with you, Matt. Pretty much in everything you say. Like, I agree that like once you reach a certain level, man, yeah, like you were so privy to so much proprietary information. You could leave here as a VP or a C-suite person and seriously do some damage. Or sell a business. Actually, I get that. I honestly never thought about that, but it makes sense. It's like,
absolutely.
That's the most important one.
Yeah, I sell Matt my snow cone business, or Matt,
and you're across the street. Like, what are you doing? All my goodwill, it's gone.
Yeah. He's like,
I just bought my own competition.
Mine's not snow cones; it's cones of snow. Completely different.
It's shaved ice. It's totally different. Totally different. But, no snow in making of this.
Yeah, and honestly, I'll use an example that you made earlier, and is most of these people, and Charles, like, I'm with you, man. Like, I understand what you're trying to say, like, it should make you want to do other things, but like, depending on the level that you're at, how far you are into an industry, that may be impossible. Bro, let's use Hunter's thing. That guy, he's new into the industry. The first job he has, he's just learning. He loves the shit, but you treat him like dog crap and blah, blah, blah. And he's like, hey, I want to continue. I want to go somewhere else. And you're like, oh, you've got a non-compete for a year. But like, how many people can survive, or even 6 months can survive 6 months without doing anything? Or, or saying, hey, now I've got to go and completely get another job out of my industry. And like I said, if you don't have that experience, you're starting all over again. Some people don't want to build businesses, man. Like, I'll tell you, someone who did own one, I would never in my fucking life ever again own a business. Like, people suck, and taxes,
and nobody's going to care about your business the way you do, my guy.
Oh no, and it wasn't that. I was even dumber, and I bought into a franchise that I thought was really great, and they're the ones that failed me, huh?
Was it Jimmy John's?
No, they're the ones that failed me, man. And they wouldn't let me do certain things, and with them, I did sign a non-compete because when I bought into it, I couldn't because of proprietary stuff. But dude, honestly, I was like, when I was done with it, I was like, okay, I'll never do anything in this industry ever again either. So like, that worked, but that was a filler in my logistics industry thing, man. It was the logistics wasn't going right, and I was like, oh, I'll try something else. But point is, I don't know.
But there's
I just see a lot of people
too. Like, I pulled this out because it's something I read regularly, but the Bureau of Labor and Statistics in 2024 did a survey. And on that survey, they found that employers that had non-competes in place were the people that signed them were 30% more likely to be promoted compared to those that changed employers frequently. What they also did is they did a deeper dive. And what they found is that when non-competes were there, now I'm not saying that I'm all for people feeling like they're handicapped, but when you remove the ability to go across the street and work for a competitor, the employee's investment in the company was at a deeper level, which caused them to hit that advancement track a little faster.
You're trapping them. You might as well sign a fucking contract.
It is a contract. The non-compete is a contract, and you did sign it.
I have to go. I have to go do some grilling, so I'm gonna leave you guys with a couple of quick.
Wait,
things.
we haven't been grilling each other this whole time?
No, this has been fun. The thing is, if you're a business owner and you want to protect your intellectual property, we have a contract for that. It's called the non-disclosure agreement. They're very enforceable. They're very common. If we did a poll, I bet you more than half the people have some level of a non-disclosure. If you're worried about your customers, you're worried about your employees or your independent contractors,
Non-solicitation.
we have a non-solicitation agreement. We have a contract for that. If you're worried that someone might say something bad that hurts your feelings, we have a contract for that. It's called a non-disparagement clause, and it prevents you from saying things that might hurt somebody. Not defamation. That's illegal. It's about making things that are hurtful, non-disparagement. Don't say mean things. We have a contract for that. If we are trying to find a way to keep you from directly competing with the business, and we describe the business in a very specific way, we have a contract for that. It's called the non-competition agreement.
And you love those.
There are 30 million Americans who have signed a non-competition agreement as a condition precedent to having a job. 40% or thereabouts are people making under $20 an hour. They're in every single industry. They are pernicious. They are pervasive. They are not going away. The FTC made a rule in 2024, a couple of days ago, banning non-competes after a 120-day window after being published in the Federal Register. That was challenged by the U.S. Chamber of Commerce and others under this idea that is a major question or a non-delegation. It's a legal term that says the Congress did not give that agency that authority, so they're going to challenge it, which could mean that the FTC's proposed rule banning non-competes goes away. If people out there think that non-competes are gone right now, they are not gone. They are here right now. Will they be gone in 120 days? Maybe, maybe not. It really depends what happens in these different courts. If Congress acts, if you care about this issue, you can email, you can write, you can call your congressperson and say, I want you to look at the Workforce Mobility Act. It is a real act in Congress right now that bans non-competition agreements. The U.S. Chamber of Commerce's argument around authority would be completely moot. It would not matter because Congress can absolutely do that. Oh, force majeure. I love force majeure. That's only in like a catastrophic event. We're not going to talk about force majeure. That's a very specific legal
You knew it. You couldn't get through a whole podcast without that coming up at least once.
I love the jargon of the law. It's a prima facie case. Here's the thing. This is your country. This is your labor market. This is how it works. If you don't like it, do something. If you do like it, then keep up. But if you don't like it, you can't just sit here on the internet and complain. You must do something. I told so many people, many as I could, to file comments with the FTC's proposed rule. 26,000 people commented. That is amazing. That is democracy in action. The goal that we should have is to move the ball forward. Sometimes you get set back, sometimes you're offsides, but this momentum does not stop. Do not stop. Do not lose faith. Do not get cynical. What's going to happen? I know this is going to happen. I want to make sure it's very clear for everyone who's watching this. Everyone thinks the non-competes are banned. In 2 or 3 months, they're going to find out that they're not banned. And they're going to be confused. They're going to say, what happened? What's going on? This is how it plays out. The rule gets enjoined. If you want that rule to stand, you need to talk to Congress or talk to your local state legislature, because the states can ban them, no problem. Congress can ban them, no problem. 100 years ago, we had a thing called freedom of contract. It was the idea that an employer and an employee could make a deal for a certain amount of wages, and that's what stood. Then minimum wage laws were enacted, and they challenged them. Oh, my friends, how hard they fought against minimum wages, how hard they fought about overtime and all of the other regulations we take for granted, like child labor. They fought those things. They fought them because they said you have the freedom to enter into any contract that you want. Eventually, after Roosevelt threatened to pack the court, they changed their tune. And the New Deal legislation, all these worker protections became a thing. This non-compete stuff, this litigation, all this will all come to pass. If you want to make it better, just put in the work. And
have a conversation. Advocate for yourself. It goes back to that, just like read for yourself, sign or don't sign. You should.
If the employer is willing to pay for that conversation, they should do that, because it should not be up to the worker to hire their attorney.
As a person. No, it doesn't have to be an attorney. You can
It has to be.
It
has to be.
You can write your own letters. You can have your own. You can be your own advocate. Do you hire an attorney before you go sign a lease deal for a car? Before you go buy a car, do you hire?
This is about giving up freedom, Charles. It's something totally different than a car lease.
It's about being your own advocate, and then if you have questions, then yes, you should go get an attorney. But you should read. And how many people don't read? I can't tell you how many times I've seen, and not even just here, just in general, someone hand them a stack of paper and they sign. Like, they don't actually read it. They just look for the little markers with the yellow arrow saying sign here, and they flip through and sign. And then by the time they're done, they're like, I didn't know. Like, whose fault is that?
This is why states like Illinois require the disclosure you get an attorney, because most states don't require that.
They probably won't read that either. They'll just sign right above it.
I know you got to go, Matt, but I'll say one last thing. I also think that it stifles professional growth.
Yeah.
I mean, right. I mean, any time in the job market, man, it's difficult, man. Like, I don't care what you say, man, even when the economy's booming, you know what I mean? It can be different because jobs are filled, and then when unemployment's low, it's harder to get a job because people are being nitpicky. So, I mean, if you're trying to move up, and you've been in the market for whatever, not saying you can't stay in it, but, you get a good job, a dream job. It's everything you want. Then, like Matt said, you go in and they force you to sign a non-disclosure, and you may have already left the other company or what so have you, or you're like, oh, back to the drawing board. So I don't know. I just think it's just asking people to give up something that, like you said, Charles, I'll use that, man, is people aspire to do great things. These things, I think in the reverse, it stops people from aspiring to the next level, because a lot of people can't, step outside and say, oh, I'm going to go try something new, not that there can't be some situations, but most people
can't. If you do aspire to do great things, then the first thing you need to aspire to do is educate yourself. And if you can't have these conversations now, if you can't read these documents now, if you can't make those decisions at that level, then it's only getting worse from there as you scale things up. You should want to read it, just like lease purchase agreements should be read. And in most cases, they should never be signed.
This is at least purchase stuff. You go back to what deregulation was in 1980. I mean, I have to leave after this, but last thing I'll leave you guys with. In 1980, about 60 to 70% of all truck drivers were union. They were union truckers. On average, they made about $38,000 a year. Adjust that for inflation, it's like $110,000, $120,000 a year. When you were back in the 1980s, you could put a kid through school or buy a house or buy a car with what you do as a worker. Fast forward today, that's not what people make anymore. It's not the amount of union penetration that exists anymore. We have watched wages erode and rights erode for workers. And now this is very typical. A hiring entity will say to a new applicant or candidate, you must disclose any post-employment restrictive covenants you have currently enacted against you. So you have to give your new boss all of your contracts and say, here they are, boss, here are my contracts. And they get to choose or decide whether they hire you or not. And then you still have your own non-competition or non-solicit for the new company. We are tying up workers in so many contracts, which they don't understand, nor do they have the resources to pay to have someone else understand for them. And it is deeply unfair. It is un-American. And I cannot wait until the day these things are gone. And if they don't go away, I will in fact run for office as a single issue candidate, whether Republican or Democrat, I don't care. The only thing I'm going to run on is to ban non-competition agreements. And I will win, because this is one thing that I will not rest until they are gone.
Matt is going to be.
Can you tell us how you really feel about non-competes?
Oh, you suck, Charles. You suck, man. You so took. Oh, bro. My second one is Matt. Matt is going to be the first Republican.
Today's episode is brought to you by Medium-Sized Dogs. Medium-Sized Dogs. Ask for them by name. Gentlemen, thank you for having me on. I appreciate the chance to talk. Charles, always a pleasure, my friend. I will talk to you all very soon.
Leffler for Supreme Court. Yeah.
I want that lifetime appointment. I won't be corrupted. Please, I'm telling you, don't worry. I'm not going to go crazy. I need that lifetime appointment.
You kind of got that crazy look right now. You better hit the grill, my guy.
Just let me have a chance. I'll do so much justice. Look, I need this. Daddy needs a lifetime appointment. I only want to be impeached. Let me go. Just let me have a shot. All right. Oh wow, this is exciting.
All right, have a good one, brother. Later.
I got to go too, and I will say this on my way out. You can always say no, and if enough people say no, then the business will have to change its practice. But if there's people saying yes, then they're okay with it. That's why I say there's not a cookie cutter approach. If enough people say no to a business and they can't fill a position, they're going to have to adjust or close. If enough people pass up a promotion because they don't want that non-compete, they will say no. Your due diligence starts with yourself. Focus on that. Do your research, ask those questions, have those conversations, and don't be scared to say no, or don't be scared to ask questions. Like I said, we met in that exact arena where someone had a question, he was brought in, we had a conversation, things got changed. So if that can happen there, then I employ people to have those conversations.
I just want to point out that Charles purposely stayed on after Matt so he could have the last word.
Yep.
No. Hey, Charles, do you think
strategy, my guy?
Hey, brother.
And I don't have the crazy eyes and stuff. I just couldn't do that.
You could have, man. It would have been a slightly more entertaining. Not that it wasn't. This was extremely entertaining. But man, I appreciate you wanting to come on, man. You know, when I said I was going to have Leffler on,
I love being the underdog.
Like, yeah. No, well, I mean, brother. I mean, underdog it is, overdog, superdog, whatever. I mean, it just thanks, man. You know, I mean, honestly, you're the first person I've ever met since this has been a thing that is, you know, is on the other side of it. So it was cool to hear.
Well, I
your
see
side.
both sides. Like, just to be
Yeah.
clear, I see both sides. I understand that there's changes that have to happen, but I think it all starts on an individual level. People need to be accountable, and that means to ask questions and educate. And that you guys are doing a great job providing a platform to educate people. So kudos to you guys for doing that.
I appreciate it, man, but it was all you and Matt, man. And just again, thanks, brother, man, for coming back on so quickly and hanging out with us too, man. And I mean, showing the swing of the pendulum here. You know what I mean? How far we can go in these conversations and how deep in the things that, you know, all of us here are able to talk about, and then we can cover here in the lounge. So,
you guys
Charles,
are doing great things.
What's that, bro? Sorry.
You guys are doing great things, man. Appreciate what you guys are doing. I got stuff to do and scout stuff to do, but appreciate you guys and all you do.
All
yeah,
right, later.
Appreciate it, brother.
Later, Charles. We'll talk to you later, homie.
Later,
bro.
What's up, Marvin? Marvin, we met Marvin at Matt's when we were over there talking to Marco. Matter of fact, can't remember the name of the other guy that was with him. But what's up, Marvin? How you doing? All right, man. You have anything you want? Yeah.
I mean, we can chat about this for a minute because I mean that was a lot, but dude, like you kind of have to see it from both sides. Like, yes, inherently, like non-competes are trash. You know, like they're definitely not the way to go. But you know, I think it is a case-by-case situation. You know, like a lot of these, you know, like Matt was talking about, entry-level people that, you know, hey, you got the job. Sign this paperwork for me real quick. Nobody's going to sit there at 18, you know, to 24 years old and be like, hold on 1 second. Let me read through every single line here. Nah, man, you're jacked up. You got a job. Like, you're ready to get in there. But, you know, like TQL, that's a 2-year non-compete. That's 2 fucking years, Rob, that they just say like, oh, good luck. Go find something else.
That's, you know, my whole, I mean, I made my points, man. And I really think that, you know, I mean, is again, not that I've ever been subject to, victim of, however you want to say, a non-compete, man, except for like I told Matt, you know, but like Matt said, he's like, oh man, they just worded that wrong. That was actually a non-solicit, not a non-compete. But, you know, even that, it was the exact same situation that Matt said. They called me, man. I told them I was moving and they called me and said it. But my point is, you know, we'll just use you and I as the examples, man. You know, I mean, logistics is one of those things that you fall into. We almost all fucking agree on that. Nobody goes to career day and walks over to the fucking supply chain table. You know what I mean? You know what I'm saying? Like maybe truck driving and stuff, man. But, you know, point is this is like many industries. It's hard to learn all that there is in this industry. Even if you're only focused on one thing, drayage or traditional freight or air freight, it's a lot of time to put into it. And once you're in it, you're kind of in it. You know what I mean? Like love or hate it, you stick with it because it is interesting. It's intriguing and there is a lot of direction to take it, you know, but most people that get into this, they follow a certain path, man, you know, and it's hard. And, you know, it's like, hey, I become like I said, a dispatcher, and then you're a fleet manager, and then a terminal
but
manager.
dude, I mean, that's exactly why, like, you know, you look at my resume, dude, I've bounced around because, you know, I didn't know truly what I wanted, because to your point, man, like there's so much to do in here. And, you know, say like, even like with drayage, for example, you know, like I knew like that's what I really wanted to sink my teeth into. But, you know, certain companies that said, oh yeah, we kind of do that here and there, or, you know, yeah, you know, they'll preach to you like, yeah, this is what you need, and then you get there, and then it comes down the line, and it's like, oh fuck, I'm in the wrong spot.
Yeah,
Yeah,
and
obviously I need to make a change, but like the non-competes, dude, to say you cannot work in this industry for X amount of time is ludicrous. Now with like non-disclosure and non-solicit, like if I hand you a customer, like if I'm Mr. you know, guy that owns this company, and there's a kid in here and he's busting his ass, you know, he's got a couple customers on his plate, you know, that he brought in, but you know, I have one that, you know, I can't take care of, or, you know, someone that left, you know, they can't take care of. So I hand them to you, you know, you're feeding your pockets a little bit, yada, yada. Well, if you decide to leave, or if, you know, I fire you, like you're not taking that, because that was, you know, earned off this company. And that's fine with me, because, you know, like, like to Charles's point, that's, you know, a piece of the foundation of that business. I mean, now like this, depending on the scale of the company, it could go either way. Like, you know, you're working with this customer longer than they've been in the organization, I think you should be able to run with that. You know, it is a relationship driven business, but to say you can't do anything in that industry, like that's crazy as fuck. Like, but yeah, non-disclosure agreements, I'm cool with. Non-solicits, sure, whatever, but you can't just can people from doing anything for 2 years, a year, 6 months.
Yeah, man. You know, like I said, to me, I don't think it helps many people, very few. Like I said, I think it stifles growth, and I'm about to have to go in a minute because my son he's sick, man, so he wants to lay down.
Oh,
But
that's cool.
anyway, you know, we can just use one specific position. You know what I mean? Say you're a terminal manager, man. You know, you made it up to a terminal manager, and then when you get in that position, they say, hey, you're going to be subject to a lot more information that you didn't know in these other positions, so we need you to sign a non-compete. All right, you do it, and things don't go well. You go to leave a year, 2 years, 3 years, 5. Who gives a shit? Whatever it is later. You know what I mean? You have accrued that time and service, or that experience. But when you leave, your real only choice is to either hope that you can move up in a position, or you have to fall back down and take a position, or find something completely different outside of that to do, you know, or the industry to do. You know, that's the thing to me is it's like, you know, it puts people in a position to not fucking be free. I mean, really, it's not. I mean, to me, that's kind of what it is. Like you're taking someone's, you know, freedom of decision and choice away from them because you're afraid it's going to hurt you. And like you said, there's instances when I agree with it, and I'm with Matt. I think that all the other deals that we have, the non-solicit and the disparage stuff, and I think those cover things enough. But for you to say you cannot be a freight broker for 2 years or 1 year, whatever it is, figure it the fuck out, you know, whatever. I just don't think that's cool, unless it's a situation like Matt said, and they're going to say, hey, we'll pay you, you know, 50% of your salary through that year. So maybe you could go and get some other job and make it work. You know what I mean? But you get my point, man. Like it's taken away from people. I think that it stifles someone's professional fucking growth, man. There's no way I would be like, oh, let me go open a business or completely restart or do this other thing. Hell no, man. I'm not trying to do all that mess. So any final closing comments, questions, concerns, updates?
Not much. Catch us tomorrow. Back to our regularly scheduled program. Thank you to the Redneck Trucker. Hopefully he's there so we can be on track and resume our program.
Did you see his thing? He said, are you ready for a Saturday, Hunter?
Yep, we are working out the details. I just got to figure out when I'm heading down there. Dude, it's like a 3.5 hour drive. So
man, that's like from here to Houston, man. I'll go down there, go shopping, fuck around for a while, and then drive back tonight. That's a day trip, dog.
That's probably what I'm gonna end up doing.
I'll play. I would do that, but I'd prefer to stay.
Yeah.
Tomorrow, like Hunter said, regularly scheduled program. I'm not going to say the guest we have on because we haven't had good luck with this guest, and this is their final time. I'm saying that jokingly and seriously. Once, twice, it's all right. 3 times, man, it's kind of mean of you. But tomorrow we do have a new sponsor coming on the show. That's going to be pretty nifty. Something completely different than we've ever had. Some really, really cool shit, we think, man. And it addresses a serious issue in this industry, and Logistics Lounge gets to be a part of their rollout into our industry because they're bringing this piece of technology from somewhere else. So fucking A. Going to be a great rest of the week in the lounge too. As always, we're just going to chill, chop it up, and we might have a special guest pop in tomorrow, Mr. Hunter. I'll tell you that when we get off. We'll do this final sponsor break, and then we will chop out this piece. We'll just sit here and wait for him to get back. Yes, Corey. No, Sherline's not leaving, bro. They're not leaving. We're just we just got someone else that's going to join the fun, join the party, man. So no, Sherline is here with us for the stinking long haul, man. We have definitely built that relationship up, and both of us see the value in working with each other. Redneck, you can be a sponsor if you want, bro. I mean, sure. You got 5 on it. We have to add. It'll have to be $5.25. You got to make Hunter not feel like we won. Okay.
Mm-hmm.
All right. Appreciate everybody watching. I think it was a very good show. Hopefully all of you agree. Was worth it doing this on a Tuesday and getting away from our regularly scheduled program, as Mr. Redneck would say. Hope to see y'all back here tomorrow. As I always say, chunk the deuces. Mr. Hound, roll that beautiful bean footage.